بسم الله الرحمن الرحيم لا حول ولا قوة إلا بالله العلي العظيم الحمد لله رب العالمين وصلى الله على سيدنا محمد وآله الطيبين الطاهرين اللهم أخرجني من ظلمات الوهم وأكرمني بنور الفهم اللهم افتح علينا أبواب رحمتك وانشر علينا خزائن علومك برحمتك يا أرحم الراحمين. We continue our discussion about the rule of no harm, qa'idatul la darar. We reached point 9 of the Arabic version, page 144. شمول الحديث للأحكام العدمية. Today we have very important discussions, so inshallah please to be very attentive. There is a discussion among fuqaha, among scholars, whether qa'idatul la darar can be used to remove some rulings which are adami, negational. For example, there are 3 examples in the book, and I mention all the 3 examples because it's good exercise in fiqh as well. For example, we say wudu is wajib. Wujub al-wudu is a hukm wujudi, means existential ruling, which means affirmative ruling. Okay, wujub al-wudu. And when in some particular case wudu is going to be harmful, then qa'idatul la darar says that there is no obligation in this case. Of course, details have to be learned from fiqh. And I have to say, for those who may later watch these videos, that we are not discussing ahkam. Ahkam is according to Maraja. We are discussing fiqh and usul. It's a kind of a scholarly discussion, but no practical, implications for muqallid. So, wudu is wajib. Qa'idatul darar comes and says that if there is harm, wudu is no longer obligatory. This was very obvious, and we have had these cases like wudu and other things. But now we want to see whether something which is adami, negational, also can be removed by qa'idatul la darar. For example, in principle, although there can be other situations, but in principle, a wife has no right for divorce, unless they agree at the beginning that the wife also is going to have the right for divorce, or there are few problems that if they are there and were hidden and concealed, and then the wife afterwards realizes, that's another issue. But in principle, in most of the cases, the right for divorce is for man, for husband. So, for woman, we have a kind of ruling, or you can say we have the ruling of the right of divorce for man. For woman, we don't have it. Or you can say for woman, there is no right of divorce directly. But imagine we have a case that if this woman is not able to divorce, she is going to be harmed. For example, the husband is arrested somewhere or is in prison and there is no access, and this is going to be a very long, prison. Can a faqih say that qa'idatul la darar would come and say that not having the right for divorce for the woman is now harmful? So we remove what? Not having the right, which is negational. Do you understand? It's not like wuzu and wujub. It is adam of having the right to divorce. Okay? So this is the discussion. Or for example, suppose there is a husband who would not take care of the expenditure and the cost of his wife and children, and is not listening, and is not also divorcing. Can faqih say qa'idatul la darar implies that not having the right for divorce for the woman is now proving to be, in this case, harmful? Therefore, we give the woman, or hakim shar, of course, maybe not necessarily the woman directly, but hakim shar who can verify. Yeah, who can verify. Otherwise, every person who can say, my husband doesn't give me enough. But for example, hakim shar would be able, mujtahid would be able to look into this case, and if he can verify that this man is not paying, he can have the right of divorce, according to the, of course, request of the woman. So, this is hukm adami. Another example. In fiqh, we have zaman. Zaman means sometimes your dhimma becomes, in debt to, for example, if someone has a abd, slave, of course, when it used to be, but now we don't have this, but because when it used to be, there were rulings about this, and Islam managed to regulate and finish it. Suppose another person stops servant or a slave of someone to work. For example, this slave was supposed to go at 9 o'clock to the shop to work. One person kidnapped this slave for 2 days, 3 days, and didn't let this person to go to work. And then the owner or the master had to hire another person, for example, for 3 days and pay for it. Is the one who kidnapped this slave or didn't let him go responsible? Is he dhamin to pay for this or not? Fuqaha say yes, because he stopped someone from benefiting from what he had and caused him unnecessary cost. But what is not very clear in fiqh, and some people didn't accept it, is when someone does the same thing with a free person. So if someone comes and kidnaps, for example, or I don't know, doesn't let a free person to go to work for 2 days, 3 days, because there is no price or cost, because he's free, he's working for himself. So is he zamen, that person who didn't let him go, or he's not a zamen? Some fuqaha said here also there is responsibility because of la dharar. They say the person who stopped this free person to go, this also has to pay, because this person was not able to make his income. His family need money. Or even if they don't need money, he could have maybe just made extra money. But this was his right to be able to work. So the question is, can we use قاعدة لا ضرر in this case and say that even here that person has to pay, or we should say no? The first assumption is that that person is not dhamin. Okay? The third example. If there was a slave whose master was very harsh and he used to annoy this slave, is it possible for example, Hakim al-Shar to apply Qa'idatul La Darar and say this master, his owner, is not treating his slave properly and he's causing harm, therefore we free the slave from the control of this person. Okay? So these are three examples to show you that sometimes in fiqh we are dealing with negational rulings that may lead to harm in some context, in some cases. And we want to see whether Qa'ideh la darar can be applied here or not. Sheikh Na'ini Razwanullah Ta'ala alayh had the idea that it is not possible. We cannot use Qa'ideh la darar except in those rulings which are affirmative, existential, like wudu, like prayer, like hajj, like ownership. If they are proving in some case to be causing harm in some particular case, we can use Qa'ideh la darar. But according to Sheikh Na'ini or Mirza Na'ini, we cannot use Qa'ideh la darar for negational rulings. Okay? Because he said, he had different arguments. One of his major arguments was because here we don't have actually a legislation. Please listen carefully. For example, about talaq. The legislation is that the husband has the right for divorce. We can draw out of this another, thing. That, okay, so it means that the woman doesn't have the right for divorce. But we don't have such a thing, necessarily as a legislation. Okay? Or, for example, we say people are to be let free to work. Okay? And also people are not responsible for paying to other people. These are two principles. But if in one case it happens that someone arrests or imprisons another person, doesn't let him to work, what should we do? So Mirza Naini had the idea that Qa'ideh la darar cannot be applied to negational rulings because these are not directly legislated. But some others say no. For example, Ayatollah Khuy Rahmatullah Alayh had the idea that although we don't have Ja'lul Adam, but Adamul Ja'l is like Ja'lul Adam. Although this negational thing is not legislated, but not legislating is like legislating not. Okay? Not legislating is like legislating not. So when the right for divorce is not given to a woman, it's not mentioned, it means that it's like there's a legislation not to give it. Okay? So the silence of the legislation about this, for example, is like legislating not. Sheikh Irwani doesn't agree with this. He says, no, not legislating is not like legislating not. He says, we can say in another word, which is not, in other words, which is not very different. He says we can say, قاعدة لا ضرر, when it comes to removing, because remember we said there are two parts, لا ضرر ولا ضرار. The first part is about we have no legislation which causes harm in Islam. The second is no one can harm other people. When it comes to the first part, there is no legislation in Islam that would cause harm. Sheikh Irwani says this means legislation in general, means there is no legal approach, no legal treatment which causes harm. And legal treatment can be by having affirmative law or being silent. All is under the umbrella of legislation. Means in Islamic legal system, yeah, altogether, there is no harm. Doesn't make difference whether it is wujub or hurma or not legislating something which would imply practically, some duties. So the conclusion is that we believe قاعدة لا ضرر can be used and can be applied in both affirmative and negational cases, whether it is ahkam wujudi, existential, or you can say affirmative rulings, or adami, negational rulings. It doesn't make difference whether it is for nafyul wudu or for saying that adamu haqq zawja lit-talaq in some cases can be removed. Wudu can be removed when it is harmful. Adamu haqq zawja lit-talaq also can be removed if it is harmful. This is the general discussion. Yes.
So with Sheikh Naimi and Sheikh Rawani, what would they do in the situation about the wife wanting to do a divorce? Would they say it's not possible under any circumstances? Or?
Sheikh Irwani, of course, says yes. Mirza Naini says no. But even maybe Mirza Naini accepts in some exceptional cases when Hakim Shar does this. Okay? But he doesn't accept that the woman has the right.
How khula is different than this one?
Even in khul, the husband should agree. It's not that the wife says, for example, I don't want my mahar and I go. Even for khul, the husband should agree. Because bazl has to be accepted by the husband.
So is it legally okay to make a condition before getting married that the woman can have a right to divorce?
Yes.
Religiously is fine.
Yeah. But it has to be during a contract which is binding. For example, ضمن العقد. It has to be عقد لازم. Okay? So, as a condition for an obligatory or binding contract, like marriage itself. Marriage itself is عقد لازم. Okay? But if it's just, signing something, it's not religiously binding. It has to be شرط ضمن العقد. Means part of the act. Because act is binding, anything with that also becomes binding.
So, when they recite the act for the marriage, they have to recite the...
No, but they say وَالشَّرْطِ الْمَذْكُورِ, for example, or شُرُوطِ الْمَذْكُورَ.
So the reciter has to mention this like al-mahr al-manu?
If there are conditions, should say with the conditions which are agreed or which are mentioned, but doesn't need to say pronounce the condition, but should say وَالشَّرْطِ or شُرُوطِ الْمَذْكُورِ or مَذْكُورَ. Yes.
This would raise a lot of worms, in my opinion.
A lot of
worms, in my opinion, Because if the woman was allowed to divorce without Hakim Shah, she could, if he doesn't wash his dog, her dog, she can wash it. The Western woman would divorce.
That
if
can also be the other way
it
around.
reach the extremes, unless Hakim Shah is involved, I don't think she should be allowed to divorce.
So the thing is that if they have not agreed on anything, so the divorce is either for the husband or for the woman if it's proved to be harmful. But the procedure is that it should go through Hakim Shah.
It should be Hakim
Yes.
Shah. So all the fuqaha agree that is it.
Yeah. And you should look at it in this way, basically, because some people may say, why man has the right, woman doesn't have the right. Okay? First of all, as we said, woman can also have the right if they want. Basically, the idea is, in my humble understanding, this is my understanding, that actually no one has the right for divorce. Marriage is something to be permanent. But because Shara knows that men, if they are not given right of divorce, they can create mess. Because you cannot by force keep a man. Says, okay, if you really don't want, you can go out. Otherwise, the first assumption is there should be no divorce. In this way, you can understand better that why we say if a woman doesn't ask for the right for divorce, because no one should have the right for divorce, except men, because if men are not given the right for divorce, they can physically or financially harm. If they don't want it, you cannot force them to be into this. There have been cases in some countries, for example, when they had no divorce, husband killed their wives. Yeah? So this right is not really a kind of privilege. It's a kind of way to secure the safety of the woman. Yes?
I understand what you're saying. It's very beautifully explained. But the way I'm looking at it is like that if a woman is creating a mess, the man can go away. He has the option. But if the man is creating a mess, the woman is still dependent on the man to give her the release.
So a man who has the right of divorce but still annoys his wife, he has no excuse. He would be cursed by everyone that if you don't want this, why you are, putting pressure on this woman.
No, but most people don't know that it's happening something else in the house, outside is something different.
Okay, then they can take it to the Hakim Shah, to the court. But the idea is that there is no point, no benefit, even for the woman, to force the husband to the marriage. It's, I think, kind of disrespectful that the wife thinks that the husband is just tolerating her, and also can be harmful. This is my way of understanding, of course, very humble view. Yes?
When we say Hakim Shah, obviously, unfortunately, we have 58 countries in the world, Muslim countries. But apart from one country, we cannot see way it's in practice. So in Western society, for example, if someone has any problem, who is Hakim Shah?
They go to representative of the Hakim Shah or Marja for the Islamic part of it. For the civil law, then another story. But for Islamic law, because sometimes people maybe can go to the court and solve the problem, or maybe they don't go to the court. But Islamically, we need also to have a solution.
Okay. And last question:
in Islam, we have solution for everything.
If someone goes to the general court and get married.
Okay.
Does the Hakim Shah accept this as a proper wedding, or they have to recite nikah?
No, they should recite. If they are Muslim, they should recite Islamic nikah as well.
They have to.
Yes, they have to have Islamic. If they are not Muslim, we recognize civil marriage.
What about non-Shias?
Any person, according to, of course, if they are in their own tradition, for example, if they are people of certain religion, again, according to their own religion, they should be married. Okay, but we are talking about people who have no religion and they just marry legally, civil marriage. We consider them as husband and wife, but we say Muslims should also marry Islamically. Because in our tradition, you have to be ready to commit yourself to marriage. And that is a marriage which is Islamically recognized.
And Sigatul Nikah are necessary? Is it compulsory to say in Arabic, or it can be said in their language as well?
Yeah, this is either fatwa or ihtiyat wajib. That should be in Arabic.
Ahsant.
Yeah.
Sheikh, you said something about it being disrespectful for the woman not to accept the divorce that the husband is giving.
No. I said it seems to be disrespectful for woman to say to a husband who doesn't want her that we don't give you right of divorce so that you stay with her. Yeah? This is not very, because woman should be respected, should be feeling that she is loved and appreciated. Yeah? It's like a blessing, you know, you don't force people to keep the blessing. Yeah, we say if you don't want this blessing, you can go away. But if you want to please Allah subhanahu wa ta'ala, you remain with this blessing and look after this blessing. Okay? This is the way I understand. Okay. So, شمول الحديث للأحكام العدمية, alhamdulillah, we discussed. And now, we go to next point, point 10. تقديم الحديث على الأدلة الأولية. حديث لا ضرار or قاعدة لا ضرار. As you know, we have two things that are now somehow in conflict. The primary rule, for example, وجوب الوضوء. Okay? وجوب الوضوء is general. Whether it is harmful or not, it's there. قاعدة لا ضرر is also general, whether it is about wuzu or other things. So they overlap. Where do they overlap? In the case of a wudu which is harmful. You understand? A wudu which is harmful is where these two conflict. Because إذا قمتم إلى الصلاة فاغسلوا وجوهكم وأيديكم إلى المرافق وامسحوا برؤوسكم وأرجلكم إلى الكعبين. It doesn't say if it is not harmful. So it's general. Okay? Another thing is لا ضرر ولا ضرار في الإسلام. لا ضرر is about wuzu and anything else that if anything leads to harm, it's stopped. So in the case of wudu, which is harmful, or for example fasting, which is harmful, then there is overlap between those primary rulings like wujubul wudu, wujubul sawm, and qa'idatul la darar. Okay? What should we do? You may say, إذا تعارضا تساقطا. You say no. They are not equal. You cannot, drop both. It's very obvious that qa'idatul la darar precedes, overrides. Yeah? So when there is wudu which is not harmful, like most of the cases, you act according to the qa'idatu wujub al-wudu. When there are cases, exceptional cases in which there is harm, you act according to la darar. Yeah, it's very obvious. But fuqaha, to explain this technically, have lots of discussions. How to explain this? Why here we give preference to what? La darar. I think you can understand, you know, in your common sense, you understand that la darar is preceding. But why? There are different explanations. Some of them are not accepted by Sheikh Irwani, some are accepted. One explanation which is accepted is that, please listen very carefully. If you have two rules, and these two rules overlap, you have to find a way that both of them can be meaningful. If we say when wudu is harmful, we exclude it from wujubul wudu and act according to la darar. So qaida wujubul wudu is okay because 99% of the cases, you know, are not harmful. Qaida la darar is also okay because it has worked. But if you say when there is overlap, we don't act according to qaida la darar. Say okay. Next time is overlap between qaida la darar and another rule. Another time overlap between. So qaida la darar never becomes meaningful because always overlap with something. And if in these cases we stop acting according to qaida la darar, it's absurd. Why there is such a rule that you can never apply? Is it clear? And some people also wanted to say that it is hukumat. You remember in Usul al-Fiqh we had takhsis, takhassus, hukumat, wurud. Some have said this is hukumat. Means qaida la darar wants to say that wudu which is harmful is not wudu. But I think what we said is enough, the first one. And it's very clear. Then another discussion is, do we need to have real harm as the subject of this rule or known harm? Is the harm in reality the subject, mawdu', or the harm which is known? I am sure everyone would say that the real harm, the real harm. Normally, in 99% maybe of the cases, all the mawzu'at, all the subjects for ahkam are real things. For example, when you say dam, blood is najis, is it blood which is known or it's real blood? Real blood. Yeah? Yes. If you don't know that there is blood in this, for example, food, someone has dropped, his finger was injured, he didn't know. Okay, if he didn't know, still this is najis, but no responsibility. But if we say blood which is known is najis, it means that it's not najis. 99% maybe of ahkam is always on real subjects. Okay, not known. Why I say 99%? Because there may be exceptional cases that to be known is also important. Can you mention an example? For example, maybe, we have to discuss it in fiqh, maybe for example for moon sighting, the existence of new moon or crescent is not enough. It has to be also sin. So this is one of the cases that maybe the knowledge is also part of the subject. Otherwise, most of the time, knowledge is not part of the subject. Okay? So, real harm is the subject, not the known harm. But then a question arises. If someone made a wudu believing that wudu is not harmful, and then later it was obvious that that wudu was harmful, is his salat, because of wudu, is void? His salat is also void? Or the wudu is not void? If you say the real harm, so here it was really harmful. So this wudu was not supposed to be made. What do you do? It seems that all fuqaha would say that there is no problem in this wudu. Yeah, because he didn't know it's harmful. So how do you put these two together? On the one hand, you say real harm. On the other hand, you say if he didn't know it is harmful, it's okay. So again, lots of discussions are here. One answer, which he prefers, is that this wudu, which was in reality harmful, okay, it was not demanded by Shari, but still wudu had matlubiyah. Still wudu was good. But Shari says, I don't want you to go into trouble. I don't ask you to make wudu when it is harmful. Okay? But when this person didn't know that it is harmful, so wudu is wudu. It's not that wudu becomes totally useless. Wudu is wudu. Just the thing is that Shari said it's no longer obligatory, but because he didn't know that it is harmful, this part, okay, was not effective, was not, didn't actualize. He was ma'zur, he was, excused because he didn't know that it is harmful. Yes.
As you said that most of the time you don't have to have the knowledge if the waqi harm is there. So after having this scenario, can we say that before knowing the actual harm, we need to have a knowledge as well that it could be harmful?
Of course.
So here you have to have some knowledge.
You should have knowledge, because if you don't have knowledge, then how can you say that qa'idatul la dharar is applied here? You should know that there is harm, but not because knowledge is part of the subject. We don't say la dharara ma'luma fil Islam. No, la real dharar. But the way to establish this is knowledge. Knowledge has tariqiyya, it's not mawdu'. Okay? Because we have tariqiyya and mawdu'iyya. Okay? Knowledge is here a path, a way to establish real harm. But why, if there was real harm, still that wuzu is okay if you didn't know? Because wuzu in itself has matlubiyah. Okay? It's different from, for example, look at this example. For example, if there was a water and you thought it is tahir, and you made wuzu, and after wuzu you came to know that there was blood in that water, your wuzu is void. Why? Because real blood is the subject of najasa. And najas water has no matlubiyat for wuzu. But wuzu which is harmful, and you didn't know that's harmful, it had matlubiyah. It's not like, so the big difference between these two, making wuzu with a water which you didn't know it's najas and became obvious it's najas. This wuzu has no matlubiyah. But a wuzu that you didn't know it's harmful, and then later you know that's harmful, wuzu has matlubiyah. Means it's a desirable. It's something that shara, it has value. Desirable. Yeah. Then the next discussion is, I go to number 12, page 163 of Arabic. Ta'arud al-dhararain. This is very good also discussion. We could have made it much shorter, like the English version, but I think it's a good way of learning fiqh and usul. It's, inshallah, improving your reasoning. Ta'arud al-dhararain. So far, what we have had was always one harm for one party. Okay? Someone is making wuzu and wuzu is harmful. Or a wife whose husband is not, for example, giving her expenditure. This type of thing. Always was one. What happens when, for example, you as a hakim shar, as a mujtahid who has authority, have two people who come to you and ask for Islamic instruction, Islamic guidance, for a case that either this person is harmed or the other person is harmed. If one person was harming the other, like Samura and that Ansari person in the time of Rasulullah, that was clear. We understood it. But two people come and they have issue. For example, I mention all the examples in the book here because it's good to sharpen them. For example,
it's not in English.
One person has a cow, another person has a clay pot. The head of the cow of this person has gone into the clay pot of the other person. And they come to you. What should you do? If you say we give preference to the person who has the clay pot, the other person is harmed. If you say we break the clay pot to release the animal, the other person is harmed. So there is no way that no one is harmed. Definitely one party is harmed. Unless you make both parties harmed.
Break the pot and kill the cow.
Yeah. So, what should we do? Is it clear? Here, if they themselves agree on a solution, a musalaha, of course, that's good. Okay? These are two people who are rational, who are mature, and if they agree on a way to solve this problem, it's okay. But if none of them is happy to compromise or is not accepting any solution, it just says, I want my clay pot, that person, I want my cow. And they don't listen to anything. They don't have any way to agree. What should we do?
Both are Samrata Jindu.
Pardon?
Samrata Jindu, both of them.
So, here...
Doesn't the cow take priority because it's a living thing?
Yeah. So here we say we should see which harm is greater and to avoid that is priority. So avoid the greater harm. So it seems this is a rational way of solving the problem. But the other party is responsible for paying to the one that, because of supporting his right, we had to cause him some loss.
If he is not able to.
For example, the owner of the cow should pay to the other person because we said cow is more important. So a few dollars, a few pounds, you have to give to the other person for his clay pot. Yes.
But if he is unable to, for example, he is not a rich person who owns the cow.
Remains in debt. Yes. So he gives the milk for some days or sells water.
Or the kind of hakim shall always step in and pay on behalf of him.
If there is no way to settle this, then what is the ruling for this? Sheikh Irwani says this is qa'idatul adl wal insaf, the rule of justice and fairness. Justice seems to require this. Some people have questioned. They said we don't have such a rule as fairness and justice in this sense. But he says we can actually find a basis for this in the Quran, because Quran says وَإِذَا حَكَمْتُمْ بَيْنَ النَّاسِ أَن تَحْكُمُوا بِالْعَدْلِ. Allah says in Surah Nisa verse 58, when you judge between people, you should judge with justice. Of course, those people who don't believe Qa'idiyya Adl wal Insaf, they don't have problem with justice. The problem is with the second part, because they can say here is not a matter of justice. Yeah, because none of them has the right over the other. Both of them have rights. Okay? So Ayatollah Khouy, for example, rahmatullah alayhi, he didn't believe in this as a rule. But Sheikh Irwani believes in this as a rule.
That adl with insaf.
Pardon?
That there should be adl with insaf. I thought all of them would agree to it.
Adl, yes. But this type of things, this is a kind of, not adl, this is a kind of rational way of solving things by forcing one party to compromise about its right. Okay? I think here, maybe it's better than saying that Qa'idatul Adl wal Insaf, to say that La Dharar, this is not in the book, but I think this is a very good way of arguing. You can say, in the same way that when you have two options, please listen carefully, when you have two options, one is harmful, the other one is not harmful. Qa'idiyya la dharar says what? Assalamu alaikum.
You take the non-harmful one.
To take the non-harmful. I think we can also say that if you have two cases, and both of them are harmful, but one has extra harm, again we can say Qa'idiyya la dharar says leave the one which is more harmful. I think this is a better way of arguing for this. It's very rational. You don't need a second rule. You don't need to go to another qa'idah. The same qa'idah of la dharar can be used when you have no way to avoid harm, but you can at least reduce harm. La dharar, I think, can be used also here. Another example, he says, imagine there is a lady who is pregnant, and we have to either protect the child, the embryo, or the mother. So this case is difficult because there is harm either to the mother or to the child. He says, if we know that the mother is going to die anyway, but by aborting the child, we can at least save the mother. Then we save the mother. Yeah, because you know, either you lose both of them, or at least you can save mother. Here there is no problem. Yeah, no one says, no, you should let both of them die. It seems that we can say,
Mother should be saved.
if you have to choose between losing one or losing both, you lose one. But if it's not known that, he doesn't mention this option, but I am adding this option. But if you don't know, if there is a possibility that maybe mother dies, okay, but maybe mother doesn't die, can we abort the child to make sure that the mother survives? This is very difficult. Do you get my question? So the doctor says there is a risk, a great risk, that the mother may die, but maybe also mother doesn't die. But if we want to make sure that the child, the mother is remaining, we have to abort the child. He doesn't talk about this. And here I think if the chance of losing both is just 51-60, it's very difficult to accept that you can abort the child. It seems very difficult. But he hasn't discussed this issue. Another case that he has discussed is when it's not death of mother, it's harm for mother, a great harm. He says, إذا كانت تضررها شديدا ولكن لا يبلغ درجة الموت. The mother is not going to die, but she will be greatly harmed. What about this? He says there seems to be no reason to say abortion is forbidden in this case. He says, because if you say we have ijma, or you say that, for example, there are hadiths that say when the child is aborted, diya has to be paid. He says they cannot be stopping this application of qa'idiyya la dara. The maximum is that the mother has to pay diya.
The mother has to pay diya to whom?
To the father.
The father.
Yes. And then he says, what about doctor? Can doctor help the mother? He says, yes. Doctor can help the mother in aborting the child. In this case, that mother is going to certainly be severely harmed. But to be honest, I don't think the discussion that he has here is enough. And I think it's much more complicated than this. So as I said, and I repeat, these lessons of al-Qawa'id al-Fiqhiyyah is not ahkam. We are not, saying what you are supposed to do. This is not fatwa. It's just a kind of a study of fiqh. Yes.
This is who is decide? The woman, the doctor, the hakim, husband. Who decides?
So the woman should decide what is her duty. Every person for himself decides. If there is disagreement, then they have to go to Hakim Shar. But if the mother wants to know whether she can abort or she cannot abort, she should decide. But then doctor also decides for himself. For example, the mother says, I know that either I am dying with my child or only my child is dying, so you have to abort me. Doctor says, I respect your opinion, but I am not sure, so I cannot abort. Okay? So every person, but if mother wants to abort, for example, father says no, then here we have to have Hakim al-Shar to settle the problem. Okay. Another example, there are two neighbors. One of them wants to make a bathroom next to the wall of the other one. And the other side of the wall is, for example, the living room or guest room of the other one. It's not bathroom next to the bathroom. So he says, I need a bathroom. The other person says, this is going then to pass humidity and make our wall wet. So if we say to this person, you don't have right to make in your own home the bathroom, this is zarar. If we say you have right and then you make the wall of the other person wet, that is also zarar. What should we do? So the answer is here, because again, we have to choose between these two zarar. So we say, of course, if they agree on a solution, it's okay. But if they don't agree, first of all, we say, can you make this bathroom another place so that no one is harmed? Yes, it is true that your preference is here, but still you can make your bathroom in another place. But if that's the only place that he can make the bathroom, and the other person also says, my home is going to be wet, here then Hakim al-Shar can get involved. And he says, here it seems that what can be done at the end is, if there is no solution, because it's not a great harm, we can say we apply asalatul bara'a, and we say it's not necessary for the owner of the house to worry about the wetness of that. He can make the bathroom, but then if there is harm, he has to pay for the damage. Okay? So, alhamdulillah, we finished qa'idatul la dharar without harming anyone. We finished in 2 lessons, alhamdulillah. Inshallah, the next rule is qa'idatul nafi al-haraj. Again, one of the rules which are very much used, and that is, inshallah, we will explain. Haraj is different from dharar. Haraj is a kind of difficulty which is normally not tolerated. Not little difficulty, a very great difficulty, great hardship. Yes, inshallah we will talk about it. Alhamdulillah Rabbil Alamin.
Something has occurred in my own experience.
Yes.
I had a patient, a young lady who was in